Good afternoon, everybody, and welcome to this week's webinar. I'm delighted to welcome Bits of Freedom and Rejo Zenger to discuss the David and Goliath battle that Bits of Freedom has been fighting in the courts for the last number of months. No matter how many times they win, there always seems to be another case. But we can hear from Rejo about what's been going on and why they took the case. Just to let you know, the webinar is being recorded, and the recording will be available on our YouTube channel shortly. You can also find all of the previous webinars from Disinfolab there too. For those of you who want to use captions and translation, you go to the captions section in Zoom and select CC. Click on the arrow, enable the translation option, and select your desired language. To remind you, if you haven't been here before, we use Slido for the questions and answers session, and to carry out polls. To access Slido, you scan the QR code or go to slido.com and enter the code #disinfo. To get us started using Slido, we have two short polls. One, where are you joining from? And two, what sector do you represent? Those polls will be ongoing for the next few minutes. So during the presentation from Rejo, you can submit your questions at any time, and we'll come back to them after the presentation and put your questions to Rejo. For those of you who don't know EU Disinfolab yet, we're a not-for-profit organization gathering knowledge and expertise on disinformation in Europe. We organize these webinars to give voice to our experts and to our awesome community, to help sharing knowledge and raising awareness around the great work that's being done by many people in this space. Many of you know us through our annual conference. The good news is that the early bird registration fee is still available for about another 2 days. It closes on the 1st of June, so get in there quickly while you still can. Bits of Freedom, as I said, have been fighting Meta in a David versus Goliath battle in the courts in the Netherlands to try to get possibly the simplest, least complicated part of the Digital Services Act implemented in the Netherlands and hopefully in the rest of Europe. And we have one of their energetic policy people who has been fighting this fight in the courts, Rejo Zenger. He will present now, and don't forget to ask questions in Slido so that we can have a good conversation after this session ends. Over to you, Rejo.
Thank you, Joe. Thank you for the invitation, and thank you for this wonderful introduction. I'll need to quickly share my slides, of course. Give me a sec. If I'm not mistaken, you all can see the slides right now. So thank you for having me. Bits of free. No, first of all, these are my contact details, and I'll show you at the end as well. So if you have questions afterwards, feel free to contact me as well. So Bits of Freedom is a digital civil rights organization from the Netherlands. And when I'm being asked what we do, I think in the end, it basically boils down to this: shifting the power of technology to people. Because we, the people, know what we want. We, the people, we are the democracy. And I think it's very important that the power of technology is in the hands of people and not in the hands of a powerful few. When Joe invited me for this webinar, he provided me with a title, David versus Goliath. But actually, when I was thinking about this, I was wondering, who is Goliath anyway, in this case? And I'm sure I'll get to that in the end. In this talk, I will cover why we took Meta to court, the ride so far, so what we have been doing, how to have others enjoy the ride as well, because that's not this is not something that goes by itself, and what we have learned. Um, First, a few quick notes on why we did what we did. So I think so. We are very much involved in the in making sure that the public debate is a healthy public debate. And I don't have to tell you this, I guess, but one of the conditions for a healthy public debate is a plurality, for example, of voices and of media. The current public debate is shaped by a few very dominant platforms, and they get to decide what you get to see. And these decisions, they are being made in their financial and political interests, not in our interests. And the problem, of course, is not only that they decide, but it's the problem because they are very dominant. Why this is so much of an influence that they are having. And as a result, the public debate has become very much impoverished, I think. So many voices are being suppressed while certain others are amplified. I'm hearing very regularly from people in minority groups, for example, whose accounts have been shut down, or for example, specific topics such as the what's going on in Gaza that being shadow banned. And one of the remedies, and I think there are more than just one, but one of the remedies is that we get to decide about the source of our information, not Meta. If we are looking at the Meta platforms such as Instagram and Facebook. So I think it's very important that as a user, you can choose which information you are being served rather than just Meta deciding this. And this is where this Digital Services Act comes into play. The Digital Services Act is obviously it's a piece of a piece of legislation, so it's hard to read for many. But if I simplify certain articles, it reads like this. So Article 38, for example, it says that providers of very large online platforms, such as, for example, Instagram, that use recommender systems, this is to order and to select the content, shall provide at least one option for each recommender system, which is not based on profiling. So if they provide a recommender system where they, using a algorithm, using profiling, decide what you get to see, they also need to offer you another one, an alternative to this. And then there's Article 27, and that says providers shall allow the user to select at any time their preferred option, and that functionality shall be directly and easily accessible from the specific section. So if you are on a timeline, you should be able to switch between the different timelines, and you should be able to set your preferred option. And then there's Article 25, another very interesting article. Providers shall not design their interfaces in a way that manipulates the user or otherwise impairs the ability of the user to make free and informed decisions. So this article, it's what they usually are naming dark patterns, wants to prevent dark patterns. And dark patterns are designs of those interfaces in a way that the user's autonomy is taken away, so that you would decide, if you really had a freedom to decide, you would decide in a particular way. But how this interface is being designed, you are being pushed into making another decision. And basically, Meta is violating or was violating all three of these provisions. So, for example, Joe already mentioned is the most simple provision from the DSA is Article 38. There need to be an alternative timeline if there's one timeline that's based on profiling. And Facebook Reels, for example, was just simply missing this timeline. So this is not a very difficult legal question. Something needs to be there, it isn't there, so Meta is violating the provision. But often the violation is a bit more subtle, and I would like to give you a few examples of this. So this is the Instagram, how it looks like for most of us. And I'll just zoom in a little bit so that it's more clear. In this screen, this is the front page, so the timeline with the content that you get to see if you're not if you haven't done anything else. And give an article. No, sorry. And this timeline is obviously being built by algorithms based on profiling. So with Article 38 and 27 in the back of your mind, you would say you need to be able to change the timeline here. But how would you? If I were to ask you which is the button to switch those timelines, many of you would not be able to tell. But it turns out the logo is the button to switching the different timelines. So if you click on the logo, which would in normal situations lead you to the front page. So for example, if you were to go to the BBC website, probably, I haven't tested this, but if you were to go to the BBC website and you click on the BBC logo in the top left, you would return to the front page. Not so in Instagram. It turns out to be a menu. And here you can select. And then if you select volgend, so this is follow, which are the accounts of, so the content of the accounts of people that you are following, you end up in another screen that actually has this content in a chronological order. However, you also notice that the button in the top left has changed to like in going back. So it's not very intuitive to get into the screen. And when you are in the screen, you are being pushed to go back to the other timeline again. And this is something that happens more often and which is kind of odd. So while tracking users is the core business of Meta, this choice of yours is one of the few things that Meta is unable to remember. This is also something you get to see when you would restart the app. So you have selected an alternative timeline, but if you restart the app, you will be presented their timeline again after the restart. And on this previous screen, so you can also see that you will be urged to go back to their timeline because there's only one button, go back. If you were to go, for example, so if you have selected this timeline, but if you were to go to the direct messages, for example, you will also end up in Meta's timeline. So basically, Meta is either not offering you the option to switch to an alternative timeline at all, and if they do it in a way that prevents you from staying there. It will always lead you back to their timeline. And that's not okay, of course, because that's with this kind of actions, Meta is not being compliant with the DSA, and this is why we took it up as a legal case. And our legal case so far, in a nutshell, it's not that difficult. We started a little bit over a year ago with a complaint with the digital service coordinator. This is the enforcement agency in Ireland that is primarily responsible for enforcing the DSA onto those platforms, and we sent them a complaint. And afterwards, we didn't hear anything from them. So we as months went by, we didn't know whether they were actually reading the complaint. We didn't know whether they were actually starting an investigation. We didn't know. And then in June, the Dutch government fell and elections were announced. And because we didn't have any updates from the Irish DSC, we felt, well, we cannot wait until they make up their mind. We need to enforce the compliance of Meta onto the DSA. So then we took them to court and we started summary proceedings. And these summary proceedings, we won those very clearly. There was the judge was very clear on this. And one of the things that the judge said is that this is a fundamental right, and it's being protected in the interest of the public debate. And this public debate is fundamental to the democratic society. And in that light, the claims filed in the summary proceedings are by their nature urgent. So for the summary proceedings, you need to have urgency. And where we were saying, hey, the elections are coming up, and this is why it's urgent, the court even said, well, this is about fundamental rights, so it's urgent by their nature. The court sided with us and said Meta is violating the DSA. Meta needs to change its interface, and it needs to be doing so in 2 weeks' time. Well, that was maybe a little bit ambitious. So Meta followed up with an execution dispute, and the court gave Meta 3 months extra to implement those changes. So by the end of last year, Meta had to have the court orders implemented. And Meta started an appeal. And this appeal was in this appeal there was a ruling earlier this year, and the Court of Appeal upheld the judgment in its entirety with one exception. The exception is that the penalty payment for not being compliant with the court orders was increased from 5 million to 10 million. So the pressure on Meta for making those changes became even bigger. Well, 2 wins, you would think, we're done, this is it. But of course, it's not with Meta, because Meta has initiated cassation, which means that Meta is asking the highest court in the Netherlands to check whether all legal procedural steps have been done properly. And unfortunately, this will take us another 1.5 years in this legal battle. So where we've won twice in less than half year, this step will cost us another 1.5 years on this case. But of course, at this moment, Meta can be considered violating the DSA. And Meta also has announced substantial proceedings, but they haven't started them yet. So I'm not sure when they will come, but I am counting on an even longer legal battle than just those 2 years. And then there's, of course, the question of the implementation of the court order. Did Meta implement the orders of the court? Well, Meta mostly complied with the court order. And the people with a legal background with you, they know which is the most important word in this sentence. It's mostly, because Meta mostly complies with the court order. So to show you what this looks like these days, this is Instagram, of course. And let me zoom in again. And if you open the Instagram app, hey, there's the Instagram logo again, and not something that allows you to change the timeline, you would think. But within a second after opening the app, it will change to this. So it will show you a pull-down menu, and it tells you which of the timeline you are using at that moment. So if you click on following and the arrow next to it, you will be presented with a menu which has a couple of options. One of them is named For You, which is Meta's feed, and one is named Following, which is the feed with the content of your of the accounts you follow. So this is actually an implementation of what the court has ordered Meta to do. This is good. This is really good. So this allows you to find actually the menu to switch and to make this switch, and it does no longer, using a dark pattern, force you back to Meta's timeline. Also, if you were to choose following, and if you close the app and reopen the app, it will open with the following timeline and not with Meta's timeline. So this is really good. The same goes with the comments. So in the if you were to watch the if you were to look at the comments between a post on Instagram, in the there's a small button where you can select which comments you want to see. So the selection that Meta has made, or you want to have them just simply in chronological order and then see all of them, like I've selected here, most recent. So these are seemingly minor changes, but they do have quite an impact. First of all, what was the entire purpose of this case is that you actually can choose between the timelines, and Meta is respecting your choice. So you get to decide what's the source of the information, who decides on what you get to see. So the user gets some of its autonomy back. A side effect of this is that if you select the timeline that's based on the content of your friends, well, this timeline has an end, of course, because you only have so many friends or so many accounts you follow. And once you have scrolled through this, there is no more, and that's it. So there is no more endless scrolling. And we've received we've received many messages from people telling us, hey, thank you for enforcing this change because I'm spending way less time on Instagram than I've done in the past. All good, you would ask? Not really, because not all of the changes are presented to all of the users. So for example, Facebook, if you were to access it via the website, some users do have the old experience and some users have the new experience. And the question is, of course, why is Meta not implementing these changes for all of its users? We don't know. And then there's this other thing. The changes are just in the Netherlands. So only if you have an account which was created in the Netherlands, then you will see these changes. But if you have an account created in Belgium or Germany or Greece or any other member state, then you have the non-compliant interface. Meta's reasoning, officially, is that the court in the Netherlands only has jurisdiction over the Netherlands, so they only implement it in the Netherlands. This, of course, is a ridiculous rationale because the Dutch court found Meta not to be compliant with European legislation that applies all over Europe. So even though we won, we're not done yet because we would like to see Meta being compliant with the DSA in all of Europe. But why should Europe not rely on us for this? Well, there's a couple of reasons. First of all, strategic litigation is about changing course. So strategic litigation, this is what we've been doing. Normally you would use strategic litigation to address a problem. So to put in a problem onto the agenda. Maybe you even lose or you know you will be losing, but by doing the court case, you can put it on top of the mind of policymakers, of politicians, and by doing so, you can maybe change policies. So it's not a replacement for enforcement. If you look at the DSA, there are many enforcement mechanisms, and the most dominant one is the one from by the European Commission and this Irish Digital Service Coordinator. They should be acting. It's their work, it's their task, they get paid for it, not us. So while I think it was very helpful to do this in this particular case, I don't think this is something that we as Europe should rely on. Also, it's highly inefficient because if Meta is only implementing this in the Netherlands, it means that we would have to replicate this legal action in 26 other member states in order to have it done in all of Europe. This obviously is not very inefficient, it's very expensive, and this is not the way it should go. And also, it's not a very fair fight. So where the European Commission has investigatory powers, so they can ask Meta, they can order Meta, basically not ask, but they can order Meta to provide insights in how the systems work, in their documents, in whatever they have. We are unable to do so, so we are not playing a fair fight there. If we are going to court, Meta always says, yeah, but Bits of Freedom doesn't know how the systems work, so this is not the right ask. So this is not a very fair fight, and I think the European Commission is in a better position to do this. And it's not expensive enough. You wonder, not expensive enough for who? Well, not for Meta. It's not expensive enough for Meta, because if we are taking Meta to court, then the court will say, Meta is non-compliant, you should change your interface. And while Meta may be compliant with the court order, it doesn't cost them anything other than the legal process. They will not get a fine for not being compliant for the past couple of years. This is different for the European Commission. If the European Commission finds Meta non-compliant, they can hand Meta a huge fine. So I think these companies are only making decisions based on their own interests, and money, of course, would influence this decision. So I think if we were to enforce the DSA, it's not expensive enough for Meta to make real change. So what's in front of us? First of all, I think it's very important to celebrate and to realize we won, because it also shows we can take a stand. Even though I don't think we need to enforce, we should be the ones that are enforcing the DSA. I think it's very important to see that even a small NGO from the Netherlands is able to take Meta to court and to win. And it also shows that non-compliance does not have to be tolerated. So Meta sometimes thinks they can do whatever they want in Europe. We are showing that we will not tolerate it, and that they need to change this. And I think Meta is not the Goliath. I think the regulatory framework is, because right now, the fact that we had to do this court case is showing that there's a gap in the enforcement by the European Commission and by the Irish Digital Service Coordinator. And I think changing those, maybe even the bigger fight, the bigger work. And I think Meta is not per se the Goliath, but getting those institutions to work, that is the big fight. So I think the European Commission and Commissioner Maan, they need to step up their game. They need to do their work so that we don't have to do it. And I think it's also important that we address the broader issues. So in the beginning, I already mentioned the problem that we're facing is in part a problem because of the dominance of these platforms. So not only the DSA, the Digital Services Act, that regulates the platforms themselves, but also the Digital Markets Act that regulates the market, so the environment in which those platforms operate. That piece of legislation also needs to be better enforced. And I think we need more and better rules against manipulation of the users, so these dark patterns. And for this, the Digital Fairness Act, which is being drafted right now, is something that needs to be made into a strong piece of legislation and being enforced. And I also think we need to realize Meta is not fighting a fair fight. Meta is prolonging this court case for us, not because they think it's because they were done legal harm. No, I think they're doing this to make us frustrated, to make civil society frustrated, to make it very expensive for civil society to take it up with Meta. And we've seen many different ways of full play, bad faith from Meta. Lying in parliaments, for example, is one. So I think if we need to interact with Meta, we need to see them for who they are. So, for example, policymakers, I don't think they should invite Meta any longer for roundtables and hearing from their expertise. No, they only should invite Meta for talks if it's about talking about accountability, to hold them accountable. That's the only thing we need to invite them for, and nothing else. And last but not least, I think there's one small provision that would make the digital services extremely effective, that would save everyone a lot of time in Europe, especially the European Commission, but also organizations such as ours. I think there should be one provision added, which is 3 strikes and you're out. If Meta is found to be non-compliant with the DSA 3 times in a row, then they should not be allowed to do business in Europe anymore. And I think if we have such a provision in the DSA, Meta will be compliant very quickly. Thank you very much. This was my the story I want to tell, and I'm very happy to take questions that you may have.
Thank you, Rejo. That was an amazing tour of the case in such a short amount of time. We have a fair queue of questions. In November last year, Disinfolab published a blog post about malicious semi-compliance, which seems to be a good description of what is happening in this case. Pavlo asked a question about Meta complying in form but not in spirit, and wondering whether the courts or regulators should have a yardstick where they say you're not being serious. If I can paraphrase his question, how would you want regulators or courts to draw the line between good faith efforts and compliance theater?
Yeah, good question. Well, I think, like I already mentioned in my talk, I think there is so many examples in so many different areas where Meta specifically is not doing this with integrity, not playing the game with integrity. So I don't mind having a dispute with a company and then having to fight about this in court. But I do think if it's blatant non-compliance, so for example, if you have the Facebook Reels, it should have an alternative timeline, and it doesn't have it at all, like in not even hidden, but it's simply not there. That's not for a company like Meta. That's not a mistake. That's a very conscious decision to build it like that. And lying in parliament, for example, it's the same. And dragging a court case unnecessarily long is the same. And I think a judge or the European Commission, for example, they should have a look at how Meta operates, and then you will see a pattern that is deliberately not respecting our rules, our values, our and I think if you look at this entire picture, then we should err on the safe side and be very hard against those companies, because this is not a way that I think it's not very respectful, the way that they are doing business in Europe. Does this answer the question?
I think so. I think it's a tough question to ask where you see the dividing line, or how the dividing line should be drawn between malicious.
Yes.
I'm not sure if you want
I think there's so of course, especially legal people with legal background, they want to have very clear boundaries between this is okay, not okay. I don't think it's a very interesting question to ask in this specific case, because Meta is not somewhere near this boundary. It's very far from this boundary, on the bad side, of course. So I don't see with this company, I don't see any reason to be to think, yeah, they've maybe done this. This was a mistake or something. They are doing too much wrongly. There's too much bad behavior to be giving them the benefit of doubt. So I don't think we need a very clear dividing line there. It's because there's a cumulative actions that are problematic. Then this is why we need to be way more fierce in our enforcement.
So thank you, Rio. There are a few questions with people scratching their heads about what the European Commission is doing. It passed legislation to harmonize the European single market. It adopted a text in Article 38, which is really, really simple. We now have one rule for the Netherlands, one rule for everyone else, or one non-enforced rule for everyone else. We have one person wondering if the Commission is supporting you to do its job for it. What's wrong with why is the Commission not enforcing its own legislation that it wrote because it thought it was a good idea?
Yes, a good question as well. This is something that I am unable to answer, because you should ask the European Commission, obviously. However, so we are in touch with the European Commission as well, of course, and we asked them the same question. Hey, what's going on? This is so simple. The Dutch court already sided with us, so what's the problem? And they tell us that they have been working very hard in building up the team of people that need to do the enforcement. They have been opening a lot of simultaneous investigations, and they are promising me that there will be a lot of very interesting decisions later this year. This is something that what I'm being told, and that I have to trust them on. I'm not sure whether that's the case, whether it's actually coming. I don't know. I'm obviously also scratching my head myself because of the same question that you and the audience has, namely, this is so simple. Why does it take so long? And I think it's also interesting to add one more thing. What could be the case is that there's also a political pressure in acting for the European Commission in a certain way. We all know that in the United States, we have there's a president that is pushing back on European legislation that minimizes the power of these platforms. And it could be that the pressure from the US government is also influencing the decisions of the European Commission. But again, it's hard to say what exactly is going on within this ivory tower, because we're outside and they're in. So I can't look over their shoulders.
There's one question from a viewer who wondered how expensive this has been, with the view to enforcing European law on a country by country basis, as seems to be the only option at the moment.
Yes, that's a good question, and it's really expensive in the sense that this is like in, I think, 10% cut from the budget that Bits of Freedom has to spend on a yearly basis. Starting this case deciding to start this case in a very brief moment of time, because elections and coming up, etc. This was a very big and risky decision to take. Thankfully, we have a funder that helps us covering the costs, but it's not a sustainable solution because it's too expensive. I would like to start 4 more cases or 5 more cases, and I will have a hard time finding funders for all of these. So I think something else needs to change. The lawyers that are doing these cases are relatively expensive because they are specialized in this topic, so they're expensive. And I think they need to understand that civil society also is working hard, but for way less money, and that they should come down to our levels of salary, for example. If I don't want to ask them to do this for free, that would not be fair, I think. But I would like to ask them to do this with a salary that's normal in civil society, normal for NGOs. And I think that would help a lot because the lawyers that we need to have, those are the most expensive part of this endeavor. And I would like to add one more thing on Meta's bad faith on this. It's really hard to find lawyers that know how to do these kind of cases, because Meta has this strategy where they will do. So they have many cases, of course, at any given time, and they will ask different lawyer practices for each and every of these cases. And once these practice does business with Meta, they cannot do business with civil society against Meta because there would be a conflict of interest. So Meta is very, I think it is my guess, but it's very deliberate strategy to do business with all the different firms, all the different law firms, in order for civil society to have hardly any law firms being able to help them against Meta. So this is, again, I think, a strategy that is done with bad faith in order to make it very difficult for civil society to start cases against Meta.
Thank you. You mentioned the lack of response from Commissioner Mann for an extended period. You mentioned that you were in contact with the Commission over time. Have you had any positive communications with either the Irish regulator or the Commission in recent weeks and months?
Mm-hmm. Well, it's positive that sometimes we are being able to exchange a few emails, but that's about it, unfortunately. It's even though we know who to talk to, it's very hard to get any so to know, for example, where our complaint is, whether it's being investigated. So, for example, with the Irish DSA, Commission Naman, they sent us a letter recently that they had forwarded our case internally to their supervisory team, which I assume is a good thing. I don't know. And then only a few days later, we learned from a press release that Commissioner Maan is starting an investigation against Meta based on complaints from civil society, but we don't know whether it's our complaint. So we have hardly any information. And this is very problematic for us because not only we don't know where our complaint is and whether shall we start a case on this, a court case on this, yes or no, because that would be a waste of time if only a week later the Irish regulatory body would take a decision. But also in the long run, we don't know exactly what kind of information the European Commission and Commissioner Maan need in order to start new investigations. We don't know. So if they start an investigation, we would like to trust them to do this investigation and would like to focus on other problems, on other non-compliance. But since we don't know what's going on, it's also very hard for us to make a proper strategy that's and we need to have this because we only have a very limited capacity and financial resources, of course. So yeah, the very minimal communications from both Commissioner Maan and the European Commission is hampering our strategy a lot.
I had a question about something you said a few moments ago about the Digital Fairness Act. You have the Dutch court said that it was a fundamental right that was being breached.
Yes.
The rule is clear. The recital that backs up the article on dark patterns and nudging is also clear. I'm missing the hook on which you can hang hope that the Digital Fairness Act can deliver something more, better, broader,
Yes.
usefuler.
Good point. Well, I don't think it would clarify or something like this, like what's in the Digital Services Act, but it would expand upon dark patterns. So, for example, endless scroll in itself is not something that is prohibited under the DSA, and I think it would be very helpful if such a thing would be put down in the DFA, in the Digital Fairness Act. Regulating notifications, for example, because notifications are, especially, for example, on Snapchat, are used to lure the user into the app every time again and again and again. So it uses notifications in itself are not bad, of course, but Snapchat is using it in a way that it's not a sincere notification of the user of a new message of a friend, but it's a notification in order to grab your attention again and get you hooked up into this app again. And I think these kind of behaviors are not being or not always being regulated in the Digital Services Act, and it would be very helpful to have them in the Digital Fairness Act in order to make those apps less addictive. And if there's the room for it, I would also love to see that we could make in the Digital Fairness Act a few steps further than the Digital Services Act allows. So, for example, this talk is partially about autonomy of the user to be able to select where to decide for yourself where the information comes from. So to have some agency over the content in your timeline. And I think there are, we could take measures that could give the user even more agency than what's currently possible under the DSA. So for me, the DFA, the Digital Fairness Act, is a addition, would add some extra rules in addition to what's already regulated in the Digital Services Act. It's not a replacement or a clarification or something.
I grouped two questions together. You mentioned the current appeals that that Meta have undertaken in possible bad faith. What's the difference between the points that it's raising now with the points that it already lost on? And
Yes.
separately, and it's a question that concerns every country except the Netherlands. Do you see the possibility of the Dutch cases being used as formally or informally as precedent in similar cases in elsewhere in the EU?
Yes. So to answer the first question, basically, this audience member is asking whether Meta is bringing up is raising new points in the cassation. No. Meta is bringing up the same point over and over again. So they have been questioning our claim for urgency in the first hearing. They have done so in the appeal, and they are doing it again in cassation. This is also, by the way, a very interesting pattern. Meta is mostly debating, so I think 80% of the court case is not about whether Meta is complying with the DSA or not. It's about procedural steps. And I think this is something, again, bad faith, that is strategy of Meta. It doesn't want to have a debate, a conversation about whether the timeline is done properly or not. No, it wants to stay away from this conversation, so it will bring up only procedural points over and over again. For example, they in the appeal, they filed an appeal on every point that was being on the table in the first hearing, and then one working day before the hearing in the appeal, they pulled back all of the questions on the points raised on whether or not they comply with the DSA. What was left are questions on procedure, on urgency, etc. So this is really frustrating in a way, and I think this is why Meta is doing this, just to make sure that other organizations are reconsidering whether they would start a case against Meta and not. They want to stay away from this conversation on the actual contents of the case. And as for the second question, I'm sure that in other member states there will be similar cases because, and they will refer to our case because this is all about the Digital Services Act. It's a regulation that applies all over Europe in more or less the same way. As you already mentioned, the internal market, it's meant to be the same in all of the member states. So it's highly unlikely that a Greek court or a Spanish court would decide differently from the Dutch court. So I would expect in the near future, and I know people are already working on this, I expect in near future cases in other member states that are referring back to the case in the Netherlands, saying, hey, the Dutch court already decided this is non-compliant. We want to have the same ruling in our member state. I'm sure this will be done. But in the long run, I don't think that's a very sustainable way because that's too expensive and simply the European Commission needs to step up their game.
Yes. There's a question in the queue, which I think would be an interesting PhD thesis. Do you think that you've got 2 minutes to answer?
Yes.
Do you think could the DSA gain more legal leverage when used in combination with the GDPR or the AI Act?
So I'm supposed to do someone else's work. No. Well, I think there's definitely some interesting angles to research. So, for example, if you look in our case, if the user sets a preference to the timeline that's not based on profiling, then it also takes away the ground for, or you could argue that it takes away the ground for Meta to track the user because they are tracking the user in order to provide you personalized content on their feed. But if the user is no longer following this feed of Meta, then they don't have a ground to track the user. And this is, of course, if this would be the case, then this, of course, would be a violation of the GDPR. So I see that there's that they are interacting with each other.
Yes, I think it's an interesting question that could do with a lot of further analysis. If you were the European Commission and you had the power to rule Europe as the European Commission, what do you think is the best thing the Commission could do now?
Well, I see that the Commission, obviously, if they do an investigation and if they hand out fines, that they need to do a proper, like they need to do proper investigation, and it takes long. But I think what would be very helpful, especially in these times with geopolitical pressure, I think it would be very helpful to find a way where the European laws are being enforced, that they are being visibly and effectively being enforced and with an impact. And this means that I think they would have to do several things next to each other. So, for example, they would have to do a couple of cases that are peanuts, like this one, for example, where it's very binary, compliant, not compliant, not compliant, then a decision and a fine. So being relatively small cases that could be brought very quickly and can show, hey, we're on top of this. You need to be compliant with our legislation, and then simultaneously maybe do a couple of cases that would take longer research, bigger questions, that have more impact on the long run. But yeah, so I think you would have to have several eggs in the same basket. One way you can show, hey, we take the DSA and other pieces of legislation very seriously. You need to abide our laws, and at the same time do things, take action that helps people really. So, for example, this case is very easy and simple and shows, hey, you need to abide by our laws, whereas making sure that the dominance of those companies are being minimized. This takes obviously a little bit longer and bigger actions. Yeah, you should do both, I think, at the same time. I think that would be a very good strategy for the European Commission.
Thank you very much. And thank you for a really interesting webinar. I think we got a great deal of value for the hour that we spent with you. And thank you for your amazing work on enforcing the DSA for the benefit of everyone's fundamental rights.
Thank you.
I think you might be interested in next week's webinar, enforcing how can member states legally push the European Commission to act. We've seen the need for the Commission to get a push from somewhere to act. This recording and all of our other webinars will be on our YouTube channel. As I mentioned at the beginning, Disinfo 2026 is happening later this year. You've got till Monday to register to get the early bird advantages. Don't forget to subscribe to our newsletter if you haven't done so already. And please wait to the end of the webinar to rate the session and to suggest topics for future sessions. And with that, I will say farewell to Rejo and see you maybe next time you're in Brussels. And thank you to everyone who participated. Have a lovely afternoon. Cheerio.